There's a lot of discussion right now about plans to ban birthright citizenship. So what is birthright citizenship? Where does it come from? What does it mean? Why do we have it? Can it be banned? Let's talk about it. I'm Brian. I make videos about law, civics, stuff like that. Please share this, comment, post, repost, do whatever to get this out there so people see it. This is your law too. You deserve to understand it. Now, this is a hot topic with a lot of opinions involved. I'm going to do my best to keep mine as repressed as I can, give you some of the history of this, some of the law involved, so that as new opinions come at you over the next few days, weeks, months, you know sort of what the history is and where we're starting from. But please don't take what I say as a definitive answer on any of this. I just want this to be a platform that you can jump off of and make your own decisions. And of course, I have opinions on this, but for this particular moment, I'm going to do my best to keep them to myself. All right, let's get started. There are two basic theories of birthright citizenship. One is called Jus Soli, one is called Jus Sanguinis. Jus Soli is the sort of British common law thing from back in the feudal days. Jus Sanguinis is more the civil law French European model. Jus Soli means right of the land. Jus Sanguinis means right of the blood. Essentially, the idea is you get your citizenship either from where you're born or from who your parents were. Now today, the United States, as well as most modern countries, tend to mix the two of these and do something sort of in the middle. But these are the roots of where they came from originally. All right, now let's look at a little bit of US history. The general trend, at least for people who looked something like me, is around 1774, you were a British citizen. Around 1776, you became a citizen of whatever your state was. And when the US Constitution was signed, you became a citizen of the United States. But of course, that wasn't the case if you didn't look vaguely like me. So we're going to fast forward a bit to the next relevant point in my story, which is the Dred Scott decision in 1858. Now, Dred Scott was, we're going to call a forced laborer, because I do not want to flag the algorithm, who sued for his own freedom in federal court. But the federal court only had jurisdiction over the case if Mr. Scott was a citizen of the state of Missouri. And the U.S. Supreme Court ruled that he was not a citizen of the state of Missouri because he was a forced laborer. Forced laborers were not citizens of the state or the United States. If you're not catching my drift, Google Dred Scott. So a few years later, we have an altercation, once again, algorithm. And at the end of that civil altercation, we write 3 new amendments to the Constitution, the 13th, 14th, and 15th Amendments, also known as the Civil War Amendments. So the 14th Amendment begins with the following text. That's in here somewhere. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states where they reside. Okay. And with the passage of the 14th Amendment, birthright citizenship was applied to everyone in the United States. Now, of course, before this point, through the concept of Jus Soli, which came through the common law, birthright citizenship would have applied to everyone who looked like me. But this brought birthright citizenship to anyone who was born in the United States. And the 14th Amendment was in part written directly in response to the Dred Scott decision, and it has to be read as part of that decision. So any consideration of the 14th Amendment is often read along with the history of forced labor in the United States. Okay, so now we have birthright citizenship, and as with all amendments, now we start limiting it. Discussions about the limitations of the 14th Amendment have mostly revolved around the phrase, and subject to the jurisdiction thereof. What does that mean exactly? Now, there were 2 really important discussions about this before 1985, so let's talk about those first. The first one comes from Elk v. Wilkins in 1884. Elk v. Wilkins said that a Native American who was born within tribal authority was not born subject to the jurisdiction of the United States and therefore did not have citizenship at birth. And this case still stands, but Congress has overruled it with statute. So now there is a statutory law that says even though the United States does not have full jurisdiction on some tribal lands, people who are born on tribal lands still get full citizenship. But this is an example of how the Supreme Court has interpreted this law in the past. The question is whether the United States government has legal authority over the person. The second case is U.S. v. Wong Kim Ark, and it's from 1898. And the important thing here is that the court actually addressed who the drafters of the 14th Amendment were trying to exclude with this clause specifically. And the court said there are two groups of people who the court is trying to exclude with this clause. The first group are hostile, invading, occupying enemies, like an army that has come in here and is occupying our land. But once again, someone that we do not have any legal control over. And the second group are children of diplomatic representatives. That means like diplomats who come over here, and even though we allow them into our country, we do not exercise any authority over them. And that was sort of the whole discussion until like 1985. And in 1985, these two guys come along with a totally new argument. So these guys are named Shuck and Smith. Those are their last names. And they come up with this argument that because the 14th Amendment only applies to people who are within the jurisdiction of the United States, people who have crossed the border without going through the proper channels are not fully within their jurisdiction. Because even though people who cross over the border illegally are subject to the laws of the United States, they're not on the same jurisdictional footing as somebody who had gone through customs and through all the proper channels. Now, of course, the counter-argument to this is the person has been arrested. They are clearly in the jurisdiction of the United States, or they couldn't be arrested. Counter-argument to that, are they being arrested, or are they just being deported? These arguments go back and forth forever, and they don't necessarily have a clear outcome. But they're definitely things you should consider as this whole issue is being debated. This is going to be the crux of this debate. When a person crosses the border without going through customs, are they within the jurisdiction of the United States? And particularly, are they within the jurisdiction of the United States as that phrase is intended in the 14th Amendment? Now here is one more layer of discussion. As I said earlier, the 14th Amendment was written about forced laborers. And part of the discussion with Shuck and Smith involves the fact that neither forced laborers nor people crossing the southern border are coming across through traditional customs methods. But according to Shuck and Smith, the forced laborers came across the border with the consent of the United States, while the people crossing from the southern border come without the consent of the United States. The counterargument to this point is that in 1808, importing forced laborers was made illegal, but the practice continued for many years. So the people who continued to be imported for the next however many years, but were not excluded under the 14th Amendment, is evidence that that is not what was intended when the 14th Amendment was written, potentially. Again, these are all points and counterpoints. None of these are definitive. The last point that I wanted to make, I'm not sure if they made the point themselves and it just wasn't in the excerpt that I saw, is the fact that the forced laborers were brought across the border without their own consent, while the people coming across the southern border come across with their own consent and of their own volition. Therefore, it would be sort of unfair to hold the fact that the forced laborers were here against them, since they didn't ask to come. Of course, the counterargument to that point is that this is a question about birthright citizenship, and we're talking about a child who would have been in utero when they crossed the border and therefore didn't give consent to cross the border either. So that isn't really definitive either. Essentially, all I have are arguments with two sides. I don't think any of the arguments that I have fully close this off one way or the other. But hopefully this gets you to a point where you're ready to hear people discuss it in an intelligent way and can push back against any specious arguments that people bring up in the future. All right. Thanks for listening. I hope this was helpful. Please comment if you have any questions, if you have any further thoughts, further arguments, discussions, anything you want to add would be really helpful. Please don't say anything mean or hateful. Don't want to hear it. I really appreciate the people who have been helping me out. I'm putting a lot of work into these, and people who have been buying me things off of my Amazon wish list, I really appreciate it. I'm going to get a thank you list together soon. It's really helpful, and it's keeping me going and keeping me fed and keeping me in coffee and all the stuff that I need. So thank you very much. If you'd like to support me, please check my link tree. All right. Thanks a lot, guys. If you keep watching them, I'll keep making them, and I appreciate your support. Thanks a lot, everybody.